Hi, everyone, and welcome to our Now What series this evening. We're joined today with Meredith and Paul from Northwest Estate Law, and they're going to be talking about wills and trusts tonight. So I'm going to turn it over to you guys.
I'm going to share my screen. Okay, so I will give a quick presentation on some basic estate planning and then open it up for questions. So you want to make a will or trust, now what? Wills and trusts are under a general category of estate planning. And estate planning includes the legacy planning, which is the wills and the trusts, what happens with our stuff after we pass away, along with incapacity planning, what happens with us if we become incapacitated, and may also include healthcare and long-term care, financial long-term care planning decisions. Estate planning is really important because it puts you in control, right? In whether you do a will or a trust, you are writing in or working with an attorney who is writing into your plan all of the things that are important to you as far as what happens with your assets and who's in charge. So that is ultimately putting you in control during a time that you either don't have control because of incapacity or you have passed away. Typically, estate planning saves money to the estate as well, where it does cost some money upfront to create the documents. Typically, it will be less expensive in the long run if they're done correctly, which helps keep family fighting at a minimum. So that is usually always our goal, is how do we draft a plan that fits your needs, and put provisions in there to kind of keep families from fighting or other beneficiaries from arguing. There's a few definitions that I'll use today that I want to just tell you up front, because I typically will just use them and sometimes people don't know what they mean. So in our world, incapacity has a legal definition. Once somebody becomes incapacitated, they're typically no longer able to manage their own affairs. And this can be legally defined, or we can define it, say what it means within the walls of our documents. So typically we will put in that 1 or 2 doctors need to deem you incapacitated. Probate is the court process whereby a will or an estate that does not have any estate planning documents will distribute assets from you to the people who are either outlined in your documents, or the state says where they go if we don't have legal documents in place. And a beneficiary is a person who receives the benefit from the will or the trust. So those terms I'm going to use a little bit today, so I just wanted to get them defined up front. When you first think about creating an estate plan, there are some key things that you should definitely consider from the beginning. You know, we need to figure out if your estate is taxable. And I'll tell you what that looks like in a minute. Where do you want your assets to go? Who will be in charge of your estate, both after you pass away and if you become incapacitated? What is the makeup of your assets? Do we have unique assets? Are there real property? Is it mostly cash, brokerage accounts? How many different places do you have assets that need to be managed? And finally, will your estate go through probate? And if it is going through probate by default, would you like to avoid that? Some basics about all estates is any property that is jointly held, meaning you hold it with somebody else with right of survivorship, that will automatically go to the joint owner when you pass away, or to you if you're the survivor of the two. Beneficiary designations will distribute directly to the beneficiaries upon your death. Typically, people need to produce a death certificate, maybe sign some paperwork with the bank or any other place that you have a beneficiary designation. Those will then be distributed to the people who you've outlined in those documents. Assets in trust will be distributed according to the terms of the trust, And then for the most part, all remaining assets not in one of those other three categories will be distributed through probate. So as I said, whether or not we have a taxable estate needs to be considered in part of the plan. And that's because taxable estates, there's some things that we can do to help alleviate taxes. So if you're over $1 million in Oregon or currently 13,610 for federal, your estate will be taxable. So in a million, in Oregon, the first $1 million is tax-free. Anything above that is a graduating tax. The 13.6 for federal, that is going to drop down to about 6-7 million in 2026. So looking forward just a couple years now, that will include some additional estates that weren't taxable quite yet. If you have real estate in more than one state, we might be looking at estate tax in multiple places. But if you're married, then we can double these numbers. So with proper estate planning. So that means on the second person to die, we can use the first person's million and your million as well. The second person to die's million. So I've talked a little bit about probate. I'm just going to address it. There's another video that's been done that talks really in detail about probate, but probate is essentially the court process after we die of how our assets get from our estate to our heirs. And those are people that we've either written in a will, or again, the state will dictate who receives our property if we do not put any legal documents in place. A will does not avoid probate, and a will in and of itself, just a simple will, is not going to do anything about that tax implication. So we really need to plan for taxes if you do have a taxable estate, which can be done in the will through tax advising or in the revocable living trust. So when we create the will, the goal is that we're putting in position everybody that we want to receive the assets, who will be in charge of working with the attorney and the court to do all the steps that we need through probate. The great thing is, in creating the will, even though it's going through probate, it typically saves time and money because everything is outlined according to your wishes. We typically can waive bond, which is generally required in a probate, unless the will waives it. And bond is essentially an insurance that our personal representative, the person working with the court, is not going to steal the money or run off with it, that they're going to pay the bills. The other major document that we use is the revocable living trust. And similar to the will, this document describes who is in charge of distributing our assets and who will receive our assets after we pass away. It does not go through probate. So anything that is properly funded into the trust does not go through probate. So the trick is, if we create the revocable trust, we want to make sure we fund it. So that's filing of real property deeds. Typically, the attorney will do that, going to the bank and closing your individual accounts, moving them into the revocable living trust. During your lifetime, you are what's known as the trustee, and this is the person who is actively in charge of the trust. If you become incapacitated or once you pass away, you've nominated successor trustees, and they will act according to what you've outlined in your trust. They'll make sure taxes are done, that bills are paid, that notices go out, and eventually that beneficiaries receive the assets that you've outlined for them. Advantages of the trust include management, right? So we've had everything that is in the walls of the trust or been properly funded into the trust, our trustee gets to manage. It avoids probate. It helps protect the interest of minor children. Probate is public information. So personally for me, I want my estate plan to not go through probate, not be public information while my children are young. So that's the reason I've personally picked the revocable living trust for my estate plan. We can do that tax advantage if we're married. So moving $1 million to the second person. So when the second person passes away, we have that $2 million instead of $1 million exemption. Same thing can be done federally. Also, I think it provides a small layer of protection around our assets. Only the trustee can manage the trust assets. So it's more difficult to access trust accounts for non-trustees. Other advantages of the trust is if we become incapacitated during our lifetime, the trust manages everything. So that successor trustee can step into place and help manage our assets. Distributions are quicker. We're not relying on the court. So again, probate is that court process. With the trust, we're avoiding it. So we're not waiting on the judge's signature on things. So it can make distributions happen much quicker. If we're working with any property in multiple states, it can all be handled in one state. Whereas if we own property in multiple states, we might need multiple probates to manage those properties. So it especially gets more expensive the more states we're dealing with regard to probate. So for people that have property maybe here and then a summer home, or just share property with friends or family members, it's a great tool to avoid multiple probates. And then that all popular avoidance of disputes. We want to make sure people are playing nice, so we can put some extra provisions in the trust. Whether you're doing a will or a trust, you really need to consider who your beneficiaries are, and if we need to limit how they are to receive assets when we pass away. This can be done in the will or the trust. Distributions can be made outright to our beneficiaries, meaning once the process is complete, either probate or the administration of the trust, our beneficiaries can just receive the property, whether it's cash or real property, whatever the distribution is. If we're concerned about the beneficiaries receiving all the money at once, then we can write in those documents that the beneficiaries are to receive it over the course of their lifetime, either in chunks at specific ages or for their entire lifetime, maybe annual distributions. We can match it to income. We can really make it a unique distribution for beneficiaries. Some beneficiaries need that extra protection. If they're minors, maybe under the age of 25 or 35, we want to make sure that they're getting it in the chunks. And then once they attain those ages, once they reach 35, we can make distributions to them. If they're disabled, or especially if they're on SSI, we want to make sure that that money is not going directly to them. The risk is that we are going to put them at risk of losing benefits. And typically it's not the income that is the major loss, but some of those other benefits or wraparound services that come with SSI. So we can do something called a special needs or supplemental needs trust. If we have beneficiaries with concerns, like maybe a drinking problem, history of drug use, gambling addiction, we can really limit, again, give the trustee power over how distributions are made. And then what I mentioned earlier, just kind of keeping family disputes out of public view, that does help within the walls of the trust. And even if we're probating, we can keep protection over beneficiaries by keeping their assets in trust. And then we need to think about what happens if a beneficiary passes away before us. So do we want their share to go directly to their children? Do we want to name additional beneficiaries, maybe give it to a charity instead, put it back into the pot for the other named beneficiaries to share? There's just really a lot of options that are available. And depending on who your beneficiaries are and your ultimate distribution plan, you can really kind of work in some details to give it to who you want. For children from a prior relationship, so this is one of the hardest. If you're remarried and maybe have a mixed family, kids brought in from multiple sides, we really want to make sure what's going to the current spouse, what's going to former kids, and in what manner that's going. There's always risk if we're giving everything to the children from a prior relationship, that the current spouse can come in and ask for their marital share, which is an amount the Oregon legislature says they can have. So pre-planning, joint planning, planning with multiple attorneys sometimes have to get involved. Who will be in charge? So we want to make sure that you're putting people in position that you trust. And there's a couple different things. There's a few categories. We want to make sure that you're taken care of during your lifetime, both financially and healthcare decisions. After you pass away, through probate or the trust administration, managing your estate, and most importantly, who would be in charge of minor or disabled beneficiaries if you pass away while they're still needing assistance. So to put people in charge of finances, we do that through the trust and a document called a power of attorney. The power of attorney is another written document, so it's separate from the will, it's separate from the revocable trust. In that document, you are granting another person that we call your agent authority over financial decisions and actions. You can cancel it at any time, as long as you have capacity to do so, but it does pass away with you when you die. So the power of attorney is no longer valid if you pass away. We need to then utilize the will and or trust. Who makes a good agent? We want to make sure somebody can manage their own checkbook, right? We don't want to put somebody who's in charge who maybe doesn't manage money well, somebody that you trust. They will be allowed compensation if you allow them to have it under the document. So that's something else we can work around. If you don't have anybody, there are professionals, be it banks, professional fiduciaries. These people are always compensated. There's usually a list. If you're working with an attorney, they should have a list of professional fiduciaries and banks. It's a good idea just to interview some of them to see who you're comfortable working with. Also, we need to make sure we have somebody in charge of decisions during your lifetime for medical or personal decisions. This is done in 3 different documents: the Oregon Advance Directive, the physician's order or portable order for life-sustaining treatment, and then a general health information release. The Advance Directive is a statutory form in Oregon, and what that means is that the Oregon government tells us what should be in that, and that way it's uniform. Every doctor's office should have the same Advance Directive as another one. In this form, we nominate a healthcare representative. This person is given broad powers, unless we limit, to make decisions over medical, including placement in long-term care, operations, and also end-of-life decisions. So with the end-of-life decisions, we want to make sure we're giving them the Advance Directive. Do we want tube feeding? Do we want life support? So there's a number of questions that we go through with the Advance Directive. Typically, your agent under the Advance Directive is a good friend or family member, somebody that's willing to follow through with your decisions, especially for end of life. So for some people, they have differing views. They wouldn't make a good agent, or it'd be too emotionally difficult on them to make this decision for you. With both the power of attorney and the Advance Directive, we want as many backups as we can get. Both these documents avoid the need for court intervention of guardian and conservator down the road. So it is great if we have, again, number 1, number 2, number 3, just in case something happens to your first agent, then we're not at risk of ending up in court if you become incapacitated and need assistance with finances or medical decisions. The health information release can include all those people that we listed in the power of attorney and the Advance Directive, and anybody else that you'd be comfortable to receive information from your doctor, or relay information to others, or be present if you're in the hospital and the doctor comes in to talk to you. Both the Advance Directive and health information release should be included in your medical record, so given to your doctor the next time you see them. On the other hand, the portable orders for life-sustaining treatment, is actually a document you prepare with your doctor or healthcare provider. It becomes an order so that if you have a medical event requiring CPR, that you're giving the EMTs instruction, or the doctor's giving them an order to either complete the CPR or withhold it if that's your decision. And again, nomination of guardian over minor children. So if you have kids who are under the age of 18, we want to always include that in your estate planning documents, either as a separate document and or included in the will or trust. This person would essentially act in a parent position over your minor child or children until they attain the age of majority. A good guardian is someone that the child or children knows and is comfortable with. If they're young, somebody that engages with the child a lot. Ideally, somebody who is willing to take on multiple kids if you have more than one. And then as children get older, it becomes more, their friends become more and more important. So rather than somebody that might be a family member, maybe a local friend, someone who can keep them in the same schools district, around the same friends, that becomes really important as the children get older. The trustee, again, is somebody who just manages the trust. So if we have a revocable living trust, if we have another type of trust that I'll talk about in a minute, our trustee is the manager. Again, that's primarily going to be over finances and assets. But after we pass away, there could be ongoing trusts, right? For the minors, for the disabled beneficiaries. So we want to make sure that the trustee that we're putting into position is someone that can manage, especially a young child, if we are having the assets go into a trust for them until they're maybe 35, having backup trustees that might be younger. There's also specific types of trusts. So there's irrevocable trusts, special needs trusts, trusts over certain assets, trusts to provide benefits for Medicaid or VA purposes, if we're looking at long-term care. So we always want to incorporate some of these long-term care conversations with people that are post-retirement, conversations about guardianships with people who have young children. So the conversation can change as we age. Primarily, the most important thing that we're going to do for a disabled beneficiary is to create a supplemental needs trust, so they do not risk losing their benefits. If we are creating it for the disabled beneficiary, there's rules around that, and we refer to that as a third-party supplemental needs trust. That trust can be for the beneficiary's lifetime and then be given to anybody else, most anybody else that you want to give to after the beneficiary passes. If the beneficiary receives funds on their own, they need to create what's called a first party supplemental needs trust or first party special needs trust. And it becomes really, really important to talk to an attorney if a disabled beneficiary is about to receive or has just received any type of funds. There's also trusts for taxable estate. So if you do have more than $1 million, or especially if you're over that federal amount, we want to look at some tax savings provisions. So there's something called an ILET, which deals with life insurance. There's trusts related specifically to charities that you can do. So having a conversation with an attorney, with a financial advisor, is really important if you have a taxable estate. Again, if you are post-retirement age, we want to have that long-term care planning, asset preservation, especially if you are married. We want to make sure that if one spouse were to become ill, that the other spouse not have to go through all of their assets. So we can do that through a proper estate plan and long-term care plan consultation as well. And then finally, we also do some memorial planning. So disposition of remains, prepaid burial, cremation, just kind of preference, have a conversation about that. Would you want to be cremated? If so, where do you want your ashes? Do you have a prepaid burial somewhere? Where is that? Do you need insurance if it's in another state to move the body? So these are all conversations that are part of the basic will or trust plan. So a recap of estate planning is it's important to do because it gives you control not only over yourself, if you become incapacitated, of who you want in charge and how you want them to do things for you, but also after you pass away, how things are going to be distributed, who's in charge. It will ultimately save you money if we're looking at avoiding probate or just making probate less expensive because of that bond. You may also be able to work around taxes with some of the quick things I talked about, and avoid a need for guardian or conservator with those incapacity documents, the advance directive, and the power of attorney. Often we get the question, do I need a lawyer? Maybe, maybe not, but I will say that it's better to create a document that is well thought out with a professional, and correctly portrays what your needs are of all those things we talked about, the funds, the beneficiaries, who's in charge. It's often less expensive to go through probate with a document that meets all the criteria. It's not impossible to get a will into court that doesn't kind of meet the rules, but again, it makes it a lot more expensive. So it's always going to be less expensive if we have a proper will in place, or especially a trust. Also, it gives you an advocate if something goes sideways. So the lawyer should, be there to answer questions, to go through the documents with you, to be there if a beneficiary kind of goes sideways. So it's nice to have somebody in your ballpark. Also, attorneys specialize in different things. So there are some attorneys that specialize just in long-term care or taxable estates. So ask any attorney that you work with kind of what it is that they specialize in, or if they can hit those different things that are specific to what your needs are. And a lot of estate planning attorneys do have the ability to work in various categories. Before your meeting, you're going to want to put together a list of assets. Think about the questions or the things I just mentioned, right? Who your beneficiaries are, if any of them have unique things or special needs or concerns that you have for them. List who's going to be in control of your various roles. The trustee can be different than the healthcare representative, than the power of attorney. You can give different people different roles. It can be all one person, it can be family. So it's just really a matter of what makes sense to you. And then come up with a list of questions to ask your attorney. So sometimes it's hard to think of questions on the spot, but going through this presentation, or kind of what information you've received from other people, horror stories that you've heard of probate, or beneficiaries fighting, those are all things to help prompt your questions that you might have for your attorney. And that is my presentation. I'm sure if there's questions, I'm happy, and Paul's happy to help answer anything specific we have.
You did answer 4 questions in the Q&A. If those people feel that they still want to have that addressed further, feel free to speak up with those.
Thank you.
Well, and thank you guys so much for being here tonight and conveying all that valuable information. For anybody that is interested, our next legal information series is on March 20th, and it is So You Want to Start a Cannabis Business. Now what? We'll put information about that on our website as well. I'm going to stop the record, and if anybody has any questions, feel free to raise your hands and we can unmute you.